Bom dia a todos, sejam bem-vindos. Eu vou falar em português, em homenagem à maioria, e a um filósofo que eu gosto muito, são dois, Ariano Suassuna e professor Roberto Mangabeira Unger. Em homenagem à maioria aqui da audiência, eu optei por falar em português, deixei os amigos do painel à vontade para escolherem a língua de preferência. E o nosso painel, a gente continua a falar sobre Law and Technology, um pouco relacionado à automação de decisões judiciais, mas não só a isso. A ideia hoje aqui é a gente, na próxima 1 hora, refletir sobre questões éticas relacionadas à inteligência artificial e o direito, e aí se aprofundar nas questões do Brasil. E aí um pouco do meu objetivo aqui é trazer esse novo cenário que está acontecendo no Brasil. Se tudo aqui nos Estados Unidos, tudo que a gente tem ouvido é muito novo, no Brasil é ainda mais novo, e aí algumas provocações para a gente começar o dia hoje, ou continuar o dia hoje. Em nossa defesa, eu trouxe aqui uma notícia que alguns de vocês talvez já conhecem, mas teve um estudo em Israel que mapeou algumas decisões tomadas por poucos juízes em relação a Big Data e padrões, e aí identificaram que as decisões mais cruéis eram dadas antes da hora do almoço. Então, eles conseguiram mapear que, de fato, as decisões tomadas por esse grupo de juízes que foram analisados antes do almoço eram sempre mais cruéis. E aí a liberdade de a gente estar falando antes do almoço, a gente não sabe o risco que corre. Eu gostaria de me apresentar antes de apresentar o painel. Eu sou Visiting Researcher aqui na Law School. Trabalho com o professor Mangabeira Unger. Fiz o LLM há 15 anos atrás e tenho uma jornada aí no Brasil que mistura advocacia. Eu sou co-founder de empresas de startups no Brasil, e meu objetivo de pesquisa aqui na escola é finalizar um livro sobre o direito das startups no Brasil e qual seria uma abordagem jurídico-institucional para que o direito, não só a tecnologia, também seja escalável. Então, uma das características essenciais desse organismo chamado startup, que está viabilizando toda essa revolução que a gente ouviu mais cedo, como é que a gente, no Brasil, tem um arcabouço jurídico-institucional capaz de ser escalável, assim como a tecnologia. E, em paralelo, conhecer, lógico, e aí eu tenho passeado, tive em Stanford, na semana passada, para a principal conferência do setor, chamada Future Law, e, enfim, que é uma conferência que já existe há alguns anos, e em paralelo a esse trabalho de pesquisa eu tenho estudado muito e aprendido muito sobre o mercado e as funcionalidades de Law and Technology. E aí tem uma forma muito simples da gente colocar o tema hoje. Então, você tem direito e tecnologia. Então, no Brasil, a gente conhece muito o direito que regulamenta a tecnologia. Então, o Marco Civil da Internet, propriedade intelectual de software. Então, é o direito que influencia a tecnologia. O nosso foco aqui hoje é falar da tecnologia que resolve os problemas do direito. Então, são duas formas de Law and Technology se relacionarem, e o nosso foco hoje aqui é mais em como que tecnologia pode resolver os problemas do direito. Por fim, antes de convidar o primeiro panelista, eu gostaria de mostrar essa divisão. Esse é o principal mapa das iniciativas relacionadas à tecnologia que soluciona os problemas do direito. É uma iniciativa de Stanford. É uma pena que o professor Wilkins já foi, mas esse ano o professor Wilkins trouxe de Stanford é um professor genial, e agora ele pertence aqui à Faculty de Harvard, chamado Don Rowling, que ele vai estar falando aqui com a gente amanhã. Eu participei do seminário dele esse semestre, é incrível, recomendo a todos que estejam aqui amanhã. É um cara muito especial nessa área, um pioneiro, foi funcionário número 50 do Google, e depois de 10 anos de Google saiu, se formou em Direito, é advogado hoje e tem um olhar muito sofisticado sobre isso tudo que a gente está falando, dada a experiência que ele tem. Mas esse index, para fechar essa introdução, é a forma como se divide as iniciativas desse contexto. Então, a gente tem marketplaces jurídicos, a gente tem automação de documentos, tem a parte de gestão, parte de pesquisa, parte de educação, online dispute resolution, parte de mediação, de resolução de conflitos, e discovery, que é mais relacionados à descoberta de documentos, due diligence e questões processuais, a parte de analytics e compliance. Então, só para a gente ter são 9 áreas, segmentos, nos quais esse tema de a tecnologia resolvendo os problemas de direito são distribuídos numa metodologia pioneira que o Ron criou lá em Stanford, e agora ele faz parte aqui da nossa... Mas, enfim, então vamos lá. Eu gostaria de convidar o Nicolas Economou, que é CEO da H5. Eles se apresentam como Expert Search and Review, Data Analytics and e-Discover for Litigation and Investigation. Nicolas é Senior Advisor on Artificial Intelligence for the Future Society. A formação dele é em ciência política pela Universidade de Genebra. Fez o MBA em Wharton e é dropout da Kennedy School. Então, ele parou a Kennedy School para fundar a empresa na qual ele hoje é o CEO. E a ideia hoje aqui é o Nicolas apresentar, falar sobre what forms has legal automation taken in United States, its benefit, risks, ethical challenges, e também ofereceu uma visão de como ele acha que o mercado nos Estados Unidos estará em 2050. Nicolas, por favor.
Thank you very much, João, and thank you to the Brazilian Association for the opportunity to speak to all of you. It's an honor to be here. I want to applaud João for getting my, Greek name pronounced fairly accurately. He also invited me to use my favorite language, which would be Greek, but I'll stick with English for the benefit of everyone. So I should mention I'm not a lawyer. I come to this with sort of 2 or maybe 3 hats on. One is the hat of the political scientist, which is my training, and really thinking of the legal system as really the cornerstone of civilized society and what the adoption of AI and automation means to the citizen and to society. The second hat I have is that of the CEO of a company that pioneered artificial intelligence in civil procedure in the United States about 15, 17 years ago now. So I've contributed to the adoption of artificial intelligence in the system, and that has given me, I think, a real-world view of the benefits and risks of artificial intelligence. Loosely defined, you heard before that, it's sort of the catchphrase of the moment, AI. And actually, that's what I want to talk next, which is really about next, which is the type of automation I'll talk about. Rafael and others may talk about other types of automation. The one I'm principally interested in is the technologies that allow the automation of tasks that otherwise would require human intelligence, and especially lawyers. Ian earlier touched on a definition of artificial intelligence and reference to the Turing test. The definition I favor is the one that was coined by, that was formulated by the person who actually coined the term artificial intelligence, John McCarthy in 1956, who said that artificial intelligence is the science and engineering of intelligent machines. And if I had to just make a small change to that today with 60 years of hindsight, is simply to say that it's the science and engineering of intelligent systems. And the reason I would favor today systems to machines is because systems as a word allows for the inclusion of humans. And today, there's really no such thing as artificial intelligence that works just as a machine. It's very much in the hands of humans. Humans, in our case, very often, in the case of the law, it can be human lawyers. Sometimes judges in the US rely on AI, and I'll talk to that in a minute, because I think it raises very significant ethical questions. What sorts of humans are actually using the AI, the competence they have, the certainty we have that it all works. So that's one general definition of AI, again, the science and engineering of making intelligent systems, as I would think of it. I think an interesting thing to think about is that we probably can't have a really good definition of artificial intelligence. You'll hear different definitions. And the reason why I believe it's almost impossible to have a definition of artificial intelligence is because after 3,000 years of debates, we still don't have a good definition of what intelligence is, right? You have all sorts of different views on that. So sometimes my personal view is that the debate on the definition of artificial intelligence is somewhat misguided. We did not wait 3,000 years to decide how we'll govern human intelligence, and I don't think we have the luxury to wait until we have a definition of AI to decide how we'll govern AI. And the third comment I'd like to make around this type of automation, artificial intelligence, is that my personal view is that there is almost an excessive focus on artificial intelligence, and it really narrows the scope of our consideration as citizens, as academics, for those of you who are, or even I would suggest as legal practitioners and judges. So when we think of artificial intelligence, I think it's interesting to think about what it is, but I think it's far more interesting to think about what artificial intelligence is not. And artificial intelligence cannot bond with a sibling or a child. Artificial intelligence cannot mourn the loss of a parent. Artificial intelligence doesn't have values, doesn't have empathy or sympathy. It hasn't experienced great joy or great humiliation or suffering. My main point here being that artificial intelligence is not one thing. It's not artificial humanity. And that, I think, is an incredibly important distinction when we think about, and we'll talk about that later today, the sort of ethical challenges that one must think about as we seek to delegate to machines more and more decisions that affect humans. So that's sort of the comments I want to make on AI, and that's why I'm personally wary of comparisons that, and I would have a slightly different view that Ian had earlier when he talked about, well, a human judge has inputs and outputs, an AI judge would have inputs and outputs, so therefore it's sort of the same thing in the middle of it, sort of a black box. I think, again, the fact that artificial intelligence and not artificial humanity makes this a comparison that is, in my view, perhaps insufficient to help us deal with the challenge. I'll just end with perhaps two very practical references to cases that reflect how artificial intelligence is used in the U.S. legal system. I won't talk now as to the benefits, the risks, etc. Hopefully we can talk about that later. But just to perhaps very practically give examples, there is a well-known case in the United States called the Loomis case, L-O-O-M-I-S, Loomis. And that's the case that took place in the great state of Wisconsin, where a person by the name of Loomis pleaded guilty to some felony, and the judge in the case, in order to determine how long the sentence would be, relied on an algorithm called Compass. And that algorithm's purpose is to help determine how high a risk of recidivism the particular person was at. And so in that particular case, this algorithm determined that this person was at high risk of recidivism. That algorithm I would think of as AI. Again, you'll have different people defining AI differently, so it may fall within or without. But in this particular case, the judge relied on a black box algorithm to make a decision that affected somebody's life. So in that case, the defendant asked for the opportunity to look at the black box algorithm, to understand how that black box works. How did this algorithm work? What data was actually relied on to help assess this one person in terms of their risk of recidivism? And interestingly, the judge, I think to us, thinking as a citizen, as a political scientist, I would say, of course, if somebody's liberty is at stake and a black box algorithm is in part relied on, that person should have the right to examine the algorithm, examine the data that was fed into the algorithm, and the decision-making pathways of that algorithm that would say, you are at high risk of recidivism. And interestingly, in this case, the judge actually denied that. And the judge was really balancing two important societal values. The one was, of course, the liberty of that person. The other one was the protection of intellectual property rights, because the manufacturer of the software said, I can't show you this software, it's proprietary, etc. So that's just one case. This case was appealed to the Wisconsin Supreme Court, which actually wrote a very well-documented opinion, but let the case stand. And what was interesting about that case at the Supreme Court level of the state of Wisconsin is that, in effect, what the court said is, we'll let the case stand, but from now on, there have to be warnings on these types of algorithms. And the warnings, in effect, say, well, the data that's used in the algorithm to assess a given person may be data that does not reflect that person. And there is a bunch of warnings like that, which, if you read them all together, the way I read them, they tell you, as long as you as a judge in a court, in effect, know that this algorithm probably is not going to work accurately for that person, you can go ahead and use it. So it doesn't seem to me as a very good conclusion, but you could see that the Supreme Court of Wisconsin really struggled with the questions, but they didn't have good guidelines to think about, well, what does it mean to use AI in this interwoven human intelligence, artificial intelligence continuum that dictates that the person is going to go to jail for 6 years as opposed to maybe 2 years or 1 year. So that's one case. It was appealed to the Supreme Court of the United States, which declined to hear it. So I think in substance can be said that today in the United States, it is the law of the land that if you are found guilty of a crime, in part the length of your sentence may depend on the assessment made of you by AI. It can depend on what AI thinks of you. Is it reassuring or not? I don't know. I bet we can talk about that later. The second case I want to quickly touch on, I'll move on, is, let all the other great speakers here speak, is the second really important case in civil procedure, which is known as the Da Silva-Moore case. Da Silva, D-A-S-I-L-V-A, Moore is other word, M-O-O-R-E. That was the case in 2012 that for the first time supported, validated the use of AI in electronic discovery. Now I know that in as a civil law jurisdiction, you don't really have in Brazil a mechanism like electronic discovery here. Although, as I understand it, it's sometimes international or national investigations, arbitration. There is some of that. And I believe that, as I understand it, that there is a Clean Compliance Act that now pushes certain corporations to use electronic discovery technologies more. But in the United States, as some of you know, very often in litigation, there are literally millions, sometimes tens of millions, sometimes hundreds of millions of documents exchanged between the parties, emails, corporate documents, etc. And all of that tended to be read by attorneys. At some point that became impossible. And companies like mine, but others, came up with approaches to automate the assessments that attorneys would make. So to find, who knew what when in a case, what happened how, what were the facts of the case, what are really the key documents in this case that will prove or disprove a case. AI today does that to the point where you can have maybe 10 million documents involved in a case, email mostly, and with a team of 3 or 4 people using artificial intelligence, you can go in and truly read, in effect, every single document and find what you want. So anyway, a court, in the Silva Moore case, determined that artificial intelligence was sufficiently capable to actually automate this fact-finding mission. So today, again, it is the law of the land in the US, and I think there, again, risk and benefit there we can talk about, that we are surrendering more and more the vital fact-finding mission of the legal system to machines. And the big question is, do we know what we're doing? And I'll leave it at that for now. But.
Okay. So, thank you, Nicolas. I would love to ask you, so this year we have national elections in Brazil. It's a big thing, right? And going back to the Wisconsin-Lonix case, where you mentioned black box, and how we deal with Facebook and Google and others that influence the society as a whole, even though they have a black box to some extent, and how should the judiciary power in Brazil during national elections should deal with it in order to make it, but I'll give a few minutes to think about it, and I'll introduce Isabela. Okay? So, nossa próxima panelista, Isabela Ferrari, eu acredito que é quem menos precisa ser apresentada aqui hoje, mas de qualquer forma, Isabela é juíza federal no Brasil desde 2012, mestre e doutoranda pela UERJ, visiting researcher aqui em Harvard no ano passado e board member do Conselho da Future Society. Isabela.
Thank you, João, for the warm introduction. I would like to thank the Harvard Law School Brazilian Studies Association, and especially Bruno, Aline, João, Estevão, Clara, Luiz Felipe, everybody that was so involved in making the symposium happen. I would like also to thank the Association of Brazilian Federal Judges of Rio de Janeiro and Espírito Santo, in the person of our president, Fabrício Fernandes de Castro. Of course, I would like to thank all of you that are here today and those that have supported this symposium, since it was only an unprecedented and, why not say, a crazy idea. So, I came here today to talk to you about technology and the judiciary. And when we address this topic, we usually look at the future, at what is to come. I'm not doing that today. I came here to talk to you about what is already happening. I came here to talk to you about online courts. Online courts are courts that absorb significant tools of online dispute resolution and explore emerging digital possibilities in dispute avoidance and in the delivery of judicial services. Online courts' early antecedents go back to 2001, when the Federal Court of Australia launched the so-called e-courtroom. it was not much more than enabling written communication between the parties and the judge, much like email exchanges, along with a message board where the information was stored. It also allowed the online receipt of submission, affidavit evidence, and court orders. But even these little innovations already had a relevant impact. They allowed that parties and judges better prepared for the court hearings, which made those hearings more effective and shorter, and in some cases, even made possible that judges rule decisions without prior physical contact with the parties, what's not usual in a system that stayed the right to the day in the court. From 2001 to 2018, much happened, and the idea of an online court is starting to become a hype, especially after an upcoming reform is being designed in the United Kingdom. In UK, a so-called money claim court has been available for over a decade. This court allows the initiation of monetary claims by filling out an online form. If the defendant does not contest it or file a counterclaim, the form can be executed online. If the defendant does so, the claim is referred to a traditional court. The simple process is considered very successful and used to solve more than 60,000 claims a year of up to £100,000 each. From this excellent experience, UK wants to give one step ahead and use technology not only as a tool for improving the way courts already operate, but as highlighted by Cash, that gives me the honor to be here with us, and Rabinovich Aini, as an opportunity to reimagine how disputes can be handled, giving rise to what we could call digital justice, which is, by the way, the name of an amazing book by Professor Cash. This transformative approach has been the basis of a proposal made in 2015 by the ODR Advisory Group to the UK's Civil Justice Council, headed by the brilliant Professor Richard Susskind. The advisory group suggested the creation of an online court called Her Majesty's Online Court that would handle civil disputes valued up to £25,000 through online dispute resolution mechanisms. This court would adopt a process composed of 3 stages. The first is online evaluation, when the parties will be informed about the legal framing of their situation by automated mechanisms. The second, online facilitation, when a mix of skilled facilitators and automated negotiation tools would assist the parties in reaching an early solution through non-adversarial processes. The third is online judgment, when a physical judge offers an online decision, equally binding and enforceable as a traditional court decision. The UK Ministry of Justice has already allocated a budget to create this court, and it's expected to April 2020, what in the UK effectively means April 2020. While Her Majesty's Online Court is still a project, a real online court runs since 2016 in a Canadian province, British Columbia. It's about this ongoing experience, the British Columbia Civil Resolution Tribunal, that I'm going to talk today. Therefore, as I said, I'm not going to talk about the future. I'm going to talk about the best example we have nowadays concerning digital justice. The first thing to know is that the CRT is not properly a court, but an administrative tribunal. Even so, it has civil jurisdiction over claims that in the Brazilian and even the Canadian context would typically be handled by a court. The CRT helps British Columbia residents resolve small claim disputes of $5,000 and under. And since 2017, strata property, condominium of any amount. In a paper by Darren Thompson, legal counsel of the Ministry of the Attorney General in British Columbia, he thus outlines the operation of the CRT dispute resolution system design. As you can see, the idea is that before you get to the point where a judge rules the case, you try less costly, less adversarial, and faster alternatives. So the system is structured to make efforts to, first, avoid disputes. Second, avoid CRT case. Third, avoid the adjudication. But if you get to that point, the system is structured to guarantee that the trial is efficient, and if needed, that the enforcement will be efficient. The CRT is structured in 3 phases. The Solution Explorer, a phase of problem diagnosis, where the parties receive free legal information written in plain language regarding their situation. After answering some questions, they also get access to self-help tools such as letter templates and worksheets regarding their situation, as you can see in this image. Ready to start? Click the button that better describes your problem. Construction and renovations, employment, general, goods or service for buyers, goods or service for sellers, insurance, loans and debts, etc. Welcome to the Solution Explorer for small claims. Ready to start? Click on the button that better describes your problem. Goods or services, buyers, sellers, etc. Welcome. We're going to ask you some questions. First, why did you buy these goods or services? For personal, family, or household use, for business use, for something else? And then you get to a letter that you just fill some fields and it's like pre-made. Besides that, there are also self-help calculators to help one understand. For example, how much he owns or should receive. One of the most important effects of the Solution Explorer is to reduce the asymmetry of information between the parties, what means that their expectations become more aligned. Due to that, as highlighted many times during the symposium, the chances to reach a voluntary agreement increase. The system is also concerned in apprehending and dealing with psychological aspects of the dispute that usually are not specifically targeted by judges. The way parties feel about the dispute, for example. And the system also stimulates the party to put itself in its opponent's shoes to achieve a much faster and less stressful resolution through short videos or workbooks. The system also helps parties get into yes, highlighting essential aspects to reach a positive take on negotiation. If the parties are unable to resolve their disputes by themselves, they are referred to the second phase of the dispute resolution system, the CRT, the first of the tribunal itself. The CRT, the dispute resolution tool. At this moment, the parties will be allowed to negotiate the disputes directly through an automated negotiation tool that structures the interactions through templates and pull-down menus. If they do not reach an agreement by themselves, the automated negotiation phase is followed by a facilitative stage. A human facilitator will then try to help them to get to an agreement, which can be turned into orders that have the same power as court orders. If this phase is unsuccessful, the parties move to a final stage of adjudication. In this final stage, the adjudication phase, the parties provide their arguments and evidence about the dispute to an independent CRT member who will take abiding decision that can be enforced like a court order. This one is therefore an adversarial phase, which can be conducted online through video conferencing or even by phone. In some cases, and just some cases, this decision can be questioned in British Columbia's Provincial Court or British Columbia's Supreme Court. The entire process is expected to take, on average, 60 to 90 days, and the representation by attorneys is restricted to limited circumstances. So, parties are usually to represent themselves, what makes the use of plain language crucial to the success of the endeavor. The CRT is designed to capture data on cases handled through its system, such as the time of the process, its costs, the content of the expected decision, and so on. Therefore, it can gather valuable information that can be used not only to make the problem diagnosis phase more accurate, but also to prevent future disputes. The digital tools used in the British Columbia Civil Resolution Tribunal do not raise as much ethical concern as the risk assessment algorithms used to assist judges with sentencing decisions like the Compass in Wisconsin that Nicolas just quoted. Even so, the British Columbia Civil Resolution Tribunal example illustrates the three shifts Professor Cash associates with online courts. The first is a shift from a physical setting to a virtual or hybrid one. So, to some extent, classic court activity is replaced by online deeds that undermine physical boundaries and court operating hours. In online courts, parties access the court, communicate with each other, have their disputes decided without leaving home. The use of ODR in courts seems to be expanding from small and simple claims to more complex ones. The second shift is that one from human intervention and decision-making to automated processes. The use of algorithms that automate the process tend to allow a cost reduction and an increase in the ability to handle suits. If some highlight the potential to increase consistency and reduce bias, others, like Cathy O'Neill, emphasize the need to make those algorithms accountable to some extent. The third is the shift from dispute resolution models that value confidentiality to archetypes focused on data collecting and analysis to prevent disputes. If data is the new oil, courts also want to have access to this resource. And now, going to our final moments, we need to ask ourselves, what is the impact of online courts? First, they bring back the need to discuss basic legal concepts. For example, what is a court? Is it a place to where I go, or is it a service that is offered to me? Depending on the answer, we can reimagine and restructure the relations between the parties, the lawyers, the judges, and the civil servants. What about the right to the day in the court, or the right to a hearing? What would be the new frame of those rights? Second, the penetration of technology in courts brings new opportunities and new risks. New opportunities of having decision-making models that are cheaper, that are faster, more effective, and less adversarial. Opportunities for data mining that help us understand the relationship between settlements and institutional designs. New risks related mainly to the use of algorithms that we do not know how are working, especially if deep learning processes are involved. Risks associated with the need of algorithmic auditing that seems as necessary as obscure. In a nutshell, online courts are already operative. It's imperative to update the legal frame to this new reality. As always, technology won't wait for the law. Thank you.
Obrigado, Isabela. Eu queria, antes de apresentar o Rafael, eu queria pontuar aqui ADR, ODR e Online Courts. Então, ADR, acho que a Ana Carolina ontem falou super bem, é um método de Alternative Dispute Resolution, né? ODR é o Online Dispute Resolution. Então, você pega o método e você insere tecnologia aqui. E aí tem uma curiosidade, que no ano passado, os principais players de ODR nos Estados Unidos, a principal plataforma, que é um time que saiu do eBay e do PayPal em 1900, nos anos 2000, acho que quando a Austrália, você mencionou a Austrália, começou a iniciativa aqui pioneira, esse grupo no eBay e no PayPal, que tinha muita compra e venda no marketplace, precisavam solucionar os problemas com mais eficiência. Eles foram pioneiros aqui no Online Dispute Resolution. Isso deu muito certo. Eles resolveram zilhões de casos, foi um best case no PayPal, no eBay, e eles fizeram um spin-off e criaram uma empresa chamada Modria. Modria cresceu muito, foi pioneira, foi número 1, disparado aqui nos Estados Unidos em Online Dispute Resolution, e no ano passado eles foram comprados por uma empresa gigantesca chamada Tyler, que é o maior fornecedor de software para governo, para judiciário, Então, a Tyler comprou a maior empresa de ODR, que fazia Alternative Dispute Resolution Online, tirou ela do mercado e agora ela vai fazer só Online Courtroom. Então, é uma transformação aqui do mercado. E no Brasil a gente já tem alguns casos, algumas empresas muito focadas nisso. Tem quase que uma corrida do ouro acontecendo aqui. E aí eu fico me perguntando se o mesmo vai acontecer e alguma delas se desdobrará e se transformará no nosso Online Courtroom, ou no nosso principal fornecedor de tecnologia, para isso que a Isabela apresentou muito bem. Obrigado, Isabela. Eu gostaria de apresentar o Rafael Leite Paulo, juiz federal também, LLM em 2017 aqui na Law School, e é award-winning, ganhou algumas premiações, é um cara que tem sido muito citado como referência em hands-on experience no courtroom dele, na vara dele, onde ele trabalha, na implementação, na utilização de tecnologia, tanto para fins administrativos quanto para procedimentos judiciais. Rafael.
Well, I'm going to talk to you about something that I feel really strongly about. I hope I can get you to feel as strong or a bit stronger about it after my talk. As Isabela did, taking the issue here to the present, I would like first to take you even more back a little. So we were talking about the future. I want to take you to the past first, if you let me. So automation is not something of the future. It's actually something that humans have been doing since ancient times. So the Greeks used to have automatic doors and automatic holy water dispensers. So some kind of automation has always been working with humans throughout history. And that might surprise you. I'm going to try to sell you the idea that even you do automation all the time. You heard yesterday about Daniel Kahneman's idea of two systems working in the mind. And one of those systems, the first one, is automatic. And the second one is the one that's slower and that demands that you give it more attention to the issues you're trying to deal with. So automation, in some level, is always happening inside of you. And actually, if you stop to look at the things that you do in your daily lives, you do automation all the time. Who here already used checklists in your work? Who used templates? Isn't that automation? It's analogical, but you're automating decision-making in some way. So you do automation all the time. That's the idea that I want to sell you. You don't need to be afraid of robots. Actually, it's good to have some people afraid to make sure that things don't go haywire and get really bad. But you have to feel about automation as something that's integral to human existence. We do it all the time, and there's no running away from it. And as I said, it's ingrained in your mind. It's just something that you get, it's inside of you, and you get into the real world. But when I say that, you probably think, well, it does feel different this time. It's not like the checklists or the templates that I used to use. You probably think, nah, that guy doesn't know what he's talking about. There is something really different. But what I want to give you today, and probably this is the thing that I want to feel is really important, is you should look at automation as something, it's any process where you go from a logical and conscious decision-making procedure to something that unconscious and fast, and you're just doing it one after the other. At some point, you did go through it consciously, but you consciously shifted to this fast and unconscious thing. It happens in your mind all the time. In your work, it happens. I just want you to be conscious. But it's different now. What is different? What is different is this little thing here that you used to buy in toy stores, like we heard today. This tool made everything different. So the automation that we usually did now is much better, much more effective. So what I call analogical, that you use in templates or filling forms, with this thing, it gets really quick. So what used to be fast gets really fast, really quick, because this tool constantly gets better. And if in past days you would get a knife and there was a limit to how sharp it would be, and after a while it doesn't matter if it's really, really sharp, it doesn't go like that with this tool. It gets faster and faster, and there's no end in sight. You probably heard about Moore's Law. It's something that was proposed in the 60s, and it defines how these specific tools get better. And you're probably seeing this line and thinking, oh, I see, it's increasing and it goes fast. But you're probably missing this side here, that it's not going in the same rate that it goes here. Actually, this is what's called an exponential curve. So it starts growing, and you don't perceive how fast it's going. It's got a steady pace, and you think, I got this. I know how this is going to roll up. But when you get up here, things start to go so fast that your previous experience is no indication of what's to come. And as you see, we are exactly in that point in time. The computing power is increasing so fast that this tool is becoming capable of doing things that we weren't capable of thinking before. So that's the time that it's starting to affect our line of work. Because we, for a long time, were thinking, no, this is too complex for this tool to deal with. But that is not longer the case. As the previous talk showed to you, there are some people that know that, and I hope that you walk out of here now knowing this. This is the new real. This is a tool that is capable of dealing with automation in your work line. So, what do you need to do with that information? I hope that you now see that what years before would take tons of equipment, a whole building to process, now is on your hand with the same computing power of a 1993 computer worth $10 million. So you carry the same amount of technology and computing power in your hand. If you put this to work, you can get the same outcome that a whole country needed to pay for. So this is the reasoning behind, we heard about today that the new lawyers demand that the systems work in their hands. It's because they have a supercomputer in their hands. They had the power that would take a whole nation to span to build with them when they're walking down the street. And if you think of automation that is something integral to your existence and something that you do, you also can tap that power. Well, now shifting to law automation and trying to get you guys to see what I've been doing. Well, law automation also isn't something new. From the 1950s, there were already articles. Some of them were discussing an incredible machine in which you would type a question and magically receive an answer. So at 70 years ago, people were describing the things that we have now today. They were dreaming of it. After that, here in the West, they bought the idea, and you got the first companies like Lexis and Nexus offering access to legal knowledge easily in a rudimentary model of that asking machine. But the current state of the art, as you heard here today, are the legal startups and big companies, big law firms. They are all investing in automation and mixing the field of using this tool in the legal field. I would, to give you a grasp, I'll talk about the case of eBay and PayPal, like João just said. I'll just highlight some interesting aspects that I find. It's an online dispute resolution system. It deals with a volume of 60 million cases every year, and they have a resolution rate of 90%. I ask you, which judicial system in the world can deal with 60 million cases every year? We have one in Brazil. We have one of the biggest one, and we probably have one of the biggest outputs, and we have nowhere near this capability. And they do this with automation, with tools, algorithms. Without this, this wouldn't be possible. But there's an interesting aspect to that. And this other startup, and I like it because it was one man's idea, and he went after it. It works in the UK. It's a robot lawyer. You chat with it and say what's the legal problem that you have, and it answers what you asks questions that are necessary for your case. And what it does, it presents you with the final solution. If you need to appeal from a parking ticket that you have, the guy got a parking ticket and he was really mad about it, and he studied the case and said, oh, there are a lot of people that get these undue parking tickets and I could help them. So he built the robot, and anyone can just go there saying, they'll tell the robot in which street they got their ticket, and the robot will make the document for them to appeal it in the administrative courts. So it's working. They had 200,000 cases with 80% effectiveness. It's a self-help robot lawyer that works online 24 hours a day, dealing with many cases. And those two things have something in common. They are getting access to legal service to people that usually would not go after the judiciary. These are cases that are not worth the while for big law firms or even for lawyers. The money interest is not enough to justify it. So basically what you get without automation, people would simply not try to get their problem solved. And this is a good aspect of automation. We may end up getting it to a lot of people that usually wouldn't get any kind of service. This is just to show you who those people are. The red line is the people that live under the line of poverty, and those are usually the disenfranchised. They don't go after legal service because they simply can't. Even if they have some problem, they have to think about their living. If they don't go after the next day's meal, they will die of starvation. The guys in the green area are the ones that go after legal service, if it's cheap enough. And the pressure for those to go after legal assistance of some kind is going to increase. And with automation, that might be economically viable in no time. So in Brazil, we already have some law firms that are trying to tap that. They have systems and algorithms that go through many cases that are similar and file them with a big flow to the judiciary, and we have nothing to countermeasure that. And the tendency is that it's increasing. You got more and more people. The tendency is that you have no more of those disenfranchised in no time, and they are going to be looking for some kind of legal assistance. And without automation, it's going to be a real problem. If we don't start using it to give a solution to that, we probably will be in a standstill. There will be no place to go. You just see the caseload increasing and no solution inside. Well, but it's not only legal startups, big law firms that do automation. It's a tool that's in you, and I think it's fundamental for dealing with that kind of systemic problem that we are going to have. And individuals, as the last one, the English solution showed, can construct their own solutions, even with tools that are available today. We don't need to wait for the next level tools that will make things even easier. One example of this is my case, and let me take you to my court. Oh, sorry. It deals with its physical cases. That's a weekly workload. So, my court specializes in federal tax executions. For those here in the US, it's a bit similar to Chapter 7 bankruptcies. And, of course, I have a huge caseload. I already feel the pressure of the problems of looking for justice without receiving any service. Well, with that in my hand, I started looking what was the issue behind that huge caseload. And what I found was that on one side you got the federal government and its agencies and departments are the creditors, and they seek basically the seizure of properties and assets. Sorry for the federal judges, you already know that, but for the other audience, on the other side, you get the debitors. They are basically individuals and businesses that either want the payment, it's around 2% or less, that are capable of doing that's not because they don't want to, or they want the discharge of the execution. It's a 5-year term after everything ends, and they just need to wait for 5 years, and the debt is discharged. So that's basically my court. So it's quite easy. It makes it easier because it's less complex to automate. So it was a pretty good incentive at the time. So that's the only problem. I can get the solution to get rid of that huge caseload. So for the creditor, with his rights in mind, for him, the longer the lawsuit takes, the better. Why? Because it increases the chance of finding assets. The debtor might win in the lottery or get a big donation, or you don't know, a friend from Congress, something might happen. On the other side, you got the debtor. For him, the shorter, the better, because that makes that discharge term, and he'll only need to wait 5 years for his debt to become non-existent. So this is the conflict that I got in my hands. And trying to decide who wins was kind of tough, because on one side, you got the creditors. They are public attorneys, and they have the power of the states, and they are well paid. And they themselves have well-paid automated systems working for them. They have researching assets and access to privileged fiscal information. So they know what to do, when to do, and how to make the lawsuit last long enough. The debtor on the other side was not that good. 80% of them have little or no assets. So whatever I do, I find no money, no property, not even a car. Most of them are not represented by lawyers. They don't have access to a public defendant. It's quite difficult for them in this specific kind of case. And they have difficulties having access to justice in general. If they don't have money, it's even hard for them to get to the court. Tough aspect is that their financial life is hindered by the lawsuit for a long time. Well, what did the court end up with? A huge caseload with never-ending lawsuits, some of them lasting up to 30 years, actually some of them even older. There was an inefficient use of resource with little satisfaction of rights. Not even the creditors, nor the debtors would get any kind of satisfaction. And you had an overworked court staff, unsatisfied lawyers, and federal judges that saw little results to what they did. And no matter how hard they work, and I don't need to tell you, they do work hard, but just to illustrate that, I would like to show you an interesting time lapse.
Genius.
Thinking about automation with that is not too hard. I was already looking like a robot. It's only system one working there.
Genial. Is this one day?
Well, so with that in mind and already working like a robot, I started to make an automation feasibility analysis. I tried to say, what can I do to make this work better? So I made an analysis of the case flow in the court, and I analyzed my staff's workflow. So I did not only look to the way I worked, so I went there with my clerks and saw what they were doing, what was taking their time, what was making the lawsuits not come to me to be signed or decided. And that was all done during the annual inspection. That video was made when I was doing that. So I go through all the cases, so it's really easy to see what's hindering, what the problems are. And what I had was that many tasks could be automated, even though we have electronic systems already working, they are not made thinking by those that use it. They are made by people who make software. So people who make software know how to make software. They don't know how to make software that is good to use. It's not the same thing. And another problem was with the online garnishing order. We had around 10,000 waiting for it, and it was a good candidate at the time. And I needed to develop a system, but you don't get personnel for that. I had none of my clerks knew how to program. The court does have people that work, but they work for them, not for the court. The circuit court does have some systems, and they need everyone to do that. So I had no option then to develop them myself. I sat down and started coding. And I went to the internet and looked for alternatives to automate the computer use. And there are many. There's not a lack of programs to help you with automation. And actually, it's the current state of the tools. It's getting better, and nowadays it's easier. You have plenty of options, and in the future it's going to get even easier. You just need to don't get afraid and try to delve into this. The tool I chose was this one. It simulates the computer use. It automates keyboard taps, mouse clicks, window manipulation, and system process in general. And it's possible even to create user-friendly interfaces and standalone executables. So I just make the program, and my clerk, he doesn't need to know about programming. Everything that I program, every algorithm turns into a self-explaining window for him. He just needs to click a button, and the automation starts. Sorry about that. Well, the suggested applications for that are repetitive tasks, data gathering, and document creation. It's really good at those tasks. And also for removing system-specific nuisances. Everyone that had to use one of those systems designed by people that are good at designing systems and not using them surely knows some windows that shouldn't be there, some excessive clicks that you need to make. And with that software, you can automate everything and take that out of the way. Well, I tried to make a video with an example of it in use. It's going through a list of lawsuit numbers and using it to inform in the electronic system. Usually you'd get the clerk to type each one of them, getting the risk of a repetitive injury in his hands. But the system goes through each of them, and it's putting there. It's a simple example. It's doing it by itself, and it puts an OK at the side, telling it that it went through OK. And the user at the end, he can do other things, and when it goes through the 1,000 cases that you need to do that, he'll just click OK, and it's finished. I made it lower so you could see it, but actually it can go much faster. These are some windows of the automation scripts, just some examples of what the user sees. He doesn't see the algorithms. He just gets that with simple instructions that are, it's like me telling them what they have to do. They'll just see the window, and it will take them through. This one is a more recent system. It was deployed last month. I used this for automating decisions with sentenças de prescrição intercorrente. This is automated. The user just needs to inform this. The text is the one that I established first, and it will make adjustments according to his first analysis. And it's dynamic. It only will ask for the page number if it's actually there. So it's dynamic, and let me try to see if the video is not too good. But this one working. There's already a system by the circuit court, a drafting system. My system goes inside it and adds a button. That little robot there it's mine working. And the user gets his specific window to put in the data for the specific repetitive decision to come up. It's simple cases, repetitive, so it's really quick. He goes through, so sees what information he has to supply to the system. And it's finished. He'll click there with all the information sent. After the draft creation is clicked, all other paces are automatic. It's there. And it's a good solution because it's specific to that case. Although it's a repetitive decision, with the user input, you can make little adjustments, and it's better than what you used to have, because it will help for those that need to take the decision to the next level and to its final conclusion. This is just a screenshot of it working. There is where the system kicks in, that the new button, and that's the window they use. That's the user input.
Yeah.
So after clicking, everything is automatic. The user doesn't need to do anything more. He's not doing anything. The software does. Okay. I think I'm over my time, but this is just an example of the algorithm behind. The user doesn't need to look at it. It's something that you do, but it's not that complicated also. No. Just take one line. You just need to get everything. Are you feeling wait? So you're waiting for the window. So it's something you can grasp. It will demand some effort, but it's not impossible. So just quickly, the result specifically with the automation I implemented was it had the first automation project that we had. It had an impact in 6,000 lawsuits and more than 9,000 individuals that were affected by the system. That system specifically related to decision making that I used last month, it's 1,500 cases. Approximately $10 million were transferred to the creditors because with the system I was able to make garnishment orders much quicker. And hundreds of millions of dollars in debt have initiated their discharge term. Actually, the last one, it was around $2 billion, 8 bilhões de reais, that started the discharge term. The only issue that you had, because you still need to make some adjustment for physical attendance. Whenever you use the system, people tend to see that their lawsuits are moving, something is happening, and they will run to court, and you have so everyone wants to see their lawsuit at the same time, so you have to deal with that a physical issue already. So when we have electronic lawsuits, that won't be an issue, but nowadays you have to plan for that also. So we had some months with really high attendance to our court. But, so basically, for the court, we got rid of a lot of lawsuits that had no reason to exist. They are starting their discharge term, and things are getting much better. I started off with 30,000 lawsuits, active lawsuits, and I'm now down to 12. Probably will be down to 5,000 lawsuits in the end of next year, due to automation used in my court. Here are some final thoughts, but basically I hope you see it as something feasible that even individuals can do, but you don't have to be afraid of the algorithms, as we don't know how, we didn't know how typing machines worked, but we had a demand for it. We don't know how electricity works, but we have a demand for it. We have to have an internal demand in the legal profession for automation and have to call it to be there. If we don't, it's not going to happen, and we probably won't be a part of what's to come. I hope that I've convinced you that it's something that we have to have the need for and ask for it. And be critical and try to establish what the outcomes are. But it's something that's connected to us because it's connected to everything, and everything is going to be changed by this. Thank you very much.
Absolutamente genial, genial. E aí falo como cidadão brasileiro e como quem milita nessa área de tecnologia e direito. Se fosse possível, eu adoraria me juntar nesse esforço, investir, ser co-founder e multiplicar isso em 3, 4 meses para que todas as varas pudessem ter isso à disposição antes do final do ano. Seria um prazer. Eu queria mais uma vez agradecer Nicolas, Isabela, Rafael. A gente já passou o horário do almoço, como eu falei no início.